that don't necessarily directly relate back to formal family law proceedings. And these start to drag in ideas of estate planning, tax planning, asset protection. Invariably, there's a little bit of family law that sits around it because, that's at the heart of this concept of a blended family. And the one that I like to use as a bit of a case study here is a relatively famous case, or at least a case about a relatively famous person, which is Solomon Lew, the famous retailer. For many years, one of the major shareholders of the Myer Group, Grace Brothers Myer, and then more recently has a whole chain of retail outlets around the countryside. And you'll see there on the screen that we've summarised the core elements of this particular factual scenario being a relatively standard family trust. And this was right back, again showing my age a little bit, this is right back to the late 1990s, early 2000s when the initial catalyst for this drama started to unfold. And for those that remember back to then, there was this idea, I think it was the Liberal government at the time, but there's this idea of effectively taxing trusts as if they were companies. Now that legislation was referred to as the entity taxation legislation. It had a whole lot of really nasty potential tax outcomes. And there was a strategy that we were aware with at the time. I don't think we were quite aware as to how often and how hard people were running at it in other jurisdictions. Mr. Lew, as I understand, it's based in Victoria, had some really high-end tax lawyers down in Victoria giving him strategic advice. And their strategic advice, as we move back to the whiteboard again, was to do this. Now, I've put this under, trying to give you a few, we've talked about the Blues Brothers, we've talked about the Cure, we're now talking about Murphy's Law, which is the main reason that trust lawyers exist. In other words, anything that can go wrong will go wrong. And I've referred to this as Murphy's Law, as opposed to Murphy's Law, which is a slight play on words there. So what they did was, because under the entity taxation regime, I won't give you too much of the detail because it's sort of not relevant, but it is relevant to why this was all done. They entered into an arrangement where an asset revaluation reserve was done, and that basically uplifted the value of all of the carrying value of all of the assets of the trust to their market value, and created a big gap, a dollar gap between the carrying cost and the actual market value, because it was all uplifted up, and then that was distributed as a capital distribution down to, relevantly, one of the sons and one of the daughters of Mr. and Mrs. Lew and their spouses. So I've done the spouses in red. So that was done all urgently around the time entity taxation was due to come in. Entity taxation then got shelved. It still sits in Treasury somewhere down there in Canberra. And life moved on. They were married. It was all happy days. Documentation was very, very scant about what had actually happened. Fast forward about 5 or 6 years. Both relationships of both of the kids with both of their respective spouses ended at about the same point in time. And the son was going through a big divorce with his wife, daughter was going through a big divorce with her husband. And these two got together, I don't think they got together, but they got together in terms of their lawyers getting together, and they started to have a really good dig around this deed, because this was tens of millions of dollars. This was a huge amount of money that had been distributed out. So, the Lews argued that it had been gifted back in. The kids argued, well, no, based on the accounts, it was actually a loan that was still sitting on the account. And if it was a loan, then that would have to be immediately repaid down into those couples' hands, and then it would immediately form part of that matrimonial pool. So to reiterate, asset revaluation reserve because of entity taxation that never actually happened. Distribution of that asset revaluation reserve down as effectively a gift, but a straight distribution out. Everything went quiet for a number of years. There's then the relationship breakdown. On the relationship breakdown, Mr. and Mrs. Lew are arguing, well, no, the kids and our in-laws gifted the money back in. The in-laws are arguing, well, no, nothing of the sort happened. All we ever did was lend it back in. It's an at-call loan, repayable on demand. Show me the money. Now, we don't actually know what the answer was to that case study example, and in some respects it doesn't even matter what the answer was. The point is that no one read the documentation with a lot of clarity. They let life move on as life does move on, and then forgot the fact that Murphy's Law absolutely happens more often than anyone would wish.